My Lord, I'm sorry. I have committed the same mistake as some of the earlier councils. जो extracts or foreign judgments थे मैंने अभी दिए हैं.
8301.
I apologize, sir.
अब president बन गया.
Sir, I'll keep a mind of it. In future, sir, I'll be careful of it.
ये चला कर 8301 अगर निकाल लें.
May I?
जी.
Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court.
चलिए ठीक है, आगे बढ़ें.
Sir, now on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the above can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution? Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a malafide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Meram Ali, Rawalpindi District Bar, Liaquat Hussain, Al-Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Justice Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading 2 short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the 4th stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6. In the first part of the final frontier, he deals with how judges have to rise above their own personal inclinations, ideological inclinations, biases, so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision-making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary. Apart from the above, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches, allocation and distribution of cases amongst benches, attaching priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefits to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Now, of course, the author of this article eventually adorned the office of the Chief Justice of Pakistan, but nonetheless, for whatsoever reasons, no structural change could be brought about to achieve this final frontier of judicial independence. Now, this concern about the untrammeled powers, the untrammeled discretion of Chief Justices is not unique to Justice Khosa. Another future Chief Justice has also...
Mr. Salahuddin, it is a person-specific argument which you are raising before us?
Not at all, sir. What I am saying is that this argument, this concern has been raised by multiple of your lordships.
The issue before us, to come to that.
Yes. The issue that I am coming to, sir, is that there have been multiple concerns expressed by the judiciary itself about the concentration of powers in the office of the Chief Justice and the potential for abuse of those powers and the perception that it creates in the general public. Now, those are exactly the issues when Parliament is being accused of acting with...
matter relates to the institution.
Yes, sir.
Please, we are sitting to hear you.
Let's go for let's look at the law. Your point is taken. You feel that there are voices coming from the bench. Fine, point taken.
Mr. Salahuddin, whatever you are saying assumes competence. That's the
I'm
one
gonna-
of
I
the
will-
key points over there.
I will come to
All
both
of this
those.
may be right, all of this may be wrong, some of it may be right, some of it may be wrong.
I
You
will-
tell
I-
us about competence.
I will address the issue of
चीज़ तो
competence
वो है।
if your lordships will allow me.
ये तो चले किसी का अपना व्यू है होगा.
Sir, bilkul. I will just cite, not read from them, but I will cite the different judgments in which, at least I think, if I'm counting correctly, 10 members of this present bench have raised concerns about the concentration of powers in the office of the Chief Justice. And my submission would be that that in itself dispels any argument of malafide.
Does that in itself confer legislative
No, sir, it
competence
does
on
not. It
Parliament?
does not, and I will deal with those
आप
independently.
उस तरफ हैं.
I'm just completing this, sir.
Kindly tell us what you say about who is Parliament the master of the roster?
Yes,
As a matter of principle.
If you're, I will come to
उस
that,
तरफ
sir.
आइए ना, ये
I will come to that,
किसी
sir.
की कोई व्यू है, किसी की क्या व्यू है?
Yes, I will come to that. I just want to quickly cite those judgments, sir. PLD 2019, Supreme Court, page 183.
183.
Yes, sir. PLD 2021.
What proposition is this?
Sir, these are all judgments and dissenting notes and additional notes in which different judges of this court have on various occasions
I think
raised.
you should be a bit careful. With all due respect, I don't
Ji.
want to stop you from making your submissions, but you're treading on relatively thin ice here, in the sense that if you are quoting a retired judge, that's one thing. But if you are quoting sitting judges in this particular context, before a full court, when the very competency of Parliament is under challenge, I think it's better for you to just focus on. I hope you understood what I'm saying. I don't want to say anything
I'm
further.
not, and that's why I'm just
It's not.
placing
Please don't.
I would like to hear what you're
Views have been
saying.
expressed. They have been
I
expressed.
would like to
placing
hear
those
what you're saying.
judgments before
Ji.
your lordships. I'm not
Citation
you
वाला
cite
है,
them?
kindly जरा
any extraneous
उसको
material.
जरा
I'm not.
Mr. Salahuddin,
Please cite them. Please cite
Citation
them.
बताइए,
Sir,
citation.
PLD 2019, Supreme Court 183. Then PLD 2021, Supreme Court 446. There is a dissenting note in that.
कोई relevant pages आप नहीं बता रहे हमें. Relevant pages.
Sir, I'll dig them out then, sir. PLD 2021, Supreme Court 446 में, sir, it is.
इसका टाइटल केस का क्या है?
Sir, ये PM's discretionary fund है. The earlier one is.
चलो लिख के दे देंगे pages.
जी, मैं दे दूँ,
आप
sir.